Hi, this is Suzanne Bouchard, instructor with American Institute for Paralegal Studies. One of the main considerations in tort law, from the perspective of both the plaintiff and the defendant, is the issue of damages or compensation. The plaintiff worries about getting compensated for his or her injuries, while the defendant is concerned with ways to minimize his or her exposure. In this lecture, I'm going to discuss the three basic types of damages that a plaintiff can recover in a tort action, and the purpose for each. The three main types of damages are compensatory damages, punitive damages, and nominal damages. Compensatory damages, also called actual damages, are awarded to compensate the plaintiff for his or her actual harm. Compensatory damages are intended to make the plaintiff whole, or to at least try to put the plaintiff in the same position he or she would have been in had the tort never occurred. That, of course, is the ideal that on a practical level can never really be attained. For example, how can a person who's lost a limb or suffered brain damage ever be made whole? But the idea is to try. Compensatory damages include recovery for such things as medical expenses, lost wages, pain and suffering, and so forth. Compensatory damages can further be divided into general and special damages. General damages are compensatory damages that can be expected to result from the kind of harm caused by the defendant. They are damages that usually and naturally flow from this type of wrong, whatever it is. General damages include such things as emotional and physical pain and suffering, reduced quality of life, humiliation, disfigurement, that sort of thing. General damages differ from special damages, which are awarded for the specific economic losses that the plaintiff has suffered. These cover such things as past, present, and future medical costs, loss of income, reduced earning capacity, those things that can vary widely depending on the circumstances of each case. Now, in contrast to compensatory damages, punitive damages are not designed to compensate the plaintiff for harm done. Rather, punitive damages serve the societal functions of punishing the defendant and deterring similar conduct on the part of the defendant and others. Because they are non-compensatory, punitive damages are typically only awarded when the defendant's conduct is intentional or otherwise egregious. Punitive damages are generally not available for simple negligence cases. The third main category of tort damages is nominal damages. A nominal damage award usually consists of just a small monetary payment, often just $1, and is awarded when a defendant has committed a tort that has resulted in little or no harm, so that no compensatory damages are due. When a plaintiff is awarded nominal damages, that means that the fact finder has found that the plaintiff's rights were violated in some way, but that the plaintiff was not due any compensation, and that the defendant did nothing to merit the punishment of a punitive damages award. Now note that nominal damages are not appropriate in negligence cases because actual harm is an element of the tort of negligence. As a paralegal in a civil litigation practice, whether you're on the defense team or the plaintiff's team, it would be a good idea to keep these three major types of tort compensation in mind. Now, if you're not currently a student at AIPS, and if you're interested in a career in the law, please visit our website at aips.com.